In case 201101185, you were convicted of a third-degree felony, lewdness involving a child. This occurred around August 23rd, 2020, where officers responded to a report of lewdness at Walmart. The victim was 12-year-old female and her sister. She stated that the male followed her and her sister down 2 aisles of toys. She began describing what the individual was wearing and the face mask that was on as well. He pulled his shorts down to the floor. He then winked, nodded his head at her, touched his genitals with both hands, moving them up and down, and then winked a second time. She turned and walked away. She was determined to be honest and consistent in her recounting of the events. Does that sound accurate, sir?
Yes.
Now, his history of doing this, it goes back over 25 years. As a matter of fact, he went to a jury trial when he was stalking a 12-year-old. And, well, it reminds me of this.
Little children, my name is Ask Little Children.
Oh, God, this...
Oh, my God.
The FBI is involved in it, so...
The FBI? You know what?
All right, hey, stop talking to him. All right, step down here on the street, get off this property. All right, I'll be with you in a second, sir.
Thank you.
Yeah. All right, so there's your answer. This girl you've been talking to is 12 years old. You're obviously an adult, so that conversation.
Hey, forbid them not.
She is 12 years old. That is her parent. He will forbid whatever he chooses. Am I clear on that?
12 is very old. I was looking for a 6-year-old.
All right, that's disturbing.
You know what? Holy and profane, I'm holy. And so is my church, the Church of I Am Christ.
Now, some of you might have seen that. It was going around YouTube for a while. That was a man who was stalking a 12-year-old, quite similar, except in this case, this man didn't whip it out and start doing that in front of the girls. But if you can imagine, this dangerous man is already up for parole. I'll tell you the results at the end. With that, let's jump in.
And you have completed sex offender treatment.
Yes.
You've had prior lewdness charges.
Yes.
Tell me what was going through your mind at the time of this specific offense. What led to this?
But mostly what happens is I'm frustrated with life, a bunch of different things overwhelming me type of a thing. And
Okay.
becoming depressed. And when I'm in that type of a mood, then I have urges, and they were difficult to control. And I went there to buy some stuff, and just saw this girl, and just became a victim of opportunity. I
Okay.
gave in to my urges.
Now, with this offense and your prior offenses, what are some of the common factors in your prior offenses in this offense?
Common things would be depression, anxiety, stress with life, probably the age of the victim.
Okay.
All that's in common.
When did the victimization begin for you?
Guess probably back in, I don't know, 92, 93, something like that.
Do you know what triggered that?
No, probably just the stresses of life, out
Okay.
on my own, starting work, stuff like that.
How many victims would you say you've had over since 92, 93? I'm not asking for names or anything like that, just kind of a ballpark figure that aren't convicted victims.
That are convicted
That
victims.
aren't
Aren't.
convicted victims.
10 maybe.
Okay. And you've had programming prior to coming here, have you?
I was on probation, I think in 98,
Okay.
and they had me go to a outpatient therapist person.
Okay.
So I had that for about a year
Okay.
before coming here.
And with your other prior lewdness charges, not including that, did you have treatment or were you just on probation? Did you get a fine? What is
Just probation.
Okay. So my biggest concern is making sure this doesn't continue in the future. So tell me, aside from your triggers, what you've learned in programming, what you feel like is going to change if the board chooses to parole you. I mean, regardless, you have an expiration date of April 28th, 2027. So you're not going to be here for very long compared to others who may be here. So convince me that you're going to be safe to be paroled or even let out of prison at 2027.
Okay. Well, before coming in, I was able to do a reality check, and I got a lot of things in order out there to make things better for me before I even came in here.
Okay.
And since going to sex offender treatment program, the CBI, I've actually learned that a lot of the stressors and depression of life that I allowed myself to get into was caused by my thinking, how I viewed the situations that I was in. I would have a tendency to blame others or to minimize my effect on the situation and stuff like that. And so going through those exercises at the program and the one-on-ones that I've had with Mr. Ruggs, I've been able to get a better understanding of my own emotions, how to deal with them, and how to deal with the situations that happen in life, and to think of, instead of thinking negative about the situation or those involved, to try to understand things from other people's point of view or a more neutral point of view so you don't get stressed out and worked up and stuff like that.
Okay.
So I think with all of that going, I think I'll be good.
So what are your plans? What do you plan on implementing when you are back in the community that's going to help prevent some of these things?
But one of the things I'm going to do is go to a private therapist on my own and see them, yes, once or twice a month, whatever we agree upon, so I can continue to uh, find an outlet of honesty and openness that I can have with somebody that maybe I cannot have with others, and that'll help keep me on track. Then
Anything else?
I have my own place. Living alone is good, and if I live with other people, it stresses me out, so that's not good.
Okay.
I have my job waiting for me and everything. I got my family for support. They're taking care of my home and stuff like that right now while I'm in here. So I have a good support system, a good work group that I work with.
What's your job?
I was a plant manager at Wrightwood Egg Farms in Lewiston, Utah.
At where?
Lewiston, Utah.
What's the plant called?
Oh, Wrightwood Egg Farms is part of Oakdale Egg Farms.
So is that where you live in that town?
I live in North Logan.
Okay. More than likely, there'll be aftercare that you'll be required to do from the board. Are you willing to follow through with that?
Yes, I am.
There will also be sex offender A conditions where you'll have no contact with children as well. Are you willing to comply with that as well?
Yes.
What were your thoughts on your your psychological evaluation?
I thought it was pretty accurate. I really don't have anything to disagree with it or anything. Um, I do agree that aftercare might be good, something to help keep me on track. And
Okay.
as I mentioned before, do my own individual anyway. And I did find one thing interesting. He said that my crime was more of a crime of urges and stuff like that,
Mhm.
which I did not learn about in the CBI. We mostly just deal with our thoughts and our emotions. Other than that, I have nothing to say about it.
Okay. Do you take any medications, sir?
No,
Do you have any substance use history?
no,
How's your physical health? Is there anything that would prevent you from being able to complete a successful parole?
no physical ailments.
Tell me a little bit about your stalking charge back in 2013 in Montana.
You mean Missouri?
Sure, it says Montana, but
Okay.
if it's, you know more than I do, so.
I was friends with his family and stuff like that, and um, they kept inviting me over and stuff like that. So we have dinners and do activities and stuff like that. And then at one point, they found out that I was a registered sex offender, and they did not like that. And I was in the process of trying to keep the friendship going, and they were trying to create a distance so they could figure out how to deal with the situation. And I was overly aggressive in trying to uh, undo damages or repair or try to keep the friendship, and I carried it too far,
Okay.
and it just led to trouble.
Have you had other sex offense charges in other states or just in Utah?
Just in Utah.
Sir, what do you feel like overall has changed for you that's going to help you moving forward so that you don't end up back here? I know we talked about some of the things you're going to implement to try and avoid from something like this happening again. What do you feel like for you has changed in regarding that?
I think the main things is my living conditions will be good. My mental maturity much better now. A lot of that has to do with the one-on-ones that I had with Mr. Ruggs. We had some
Okay.
good talks, and also the assessing of my thinking parameters. I got to uh, deal with my negative thoughts early on and not allow them to fester and grow and replace them with better thoughts. As long
Okay.
as I keep doing that stuff, I'll be good.
Okay. Sir, is there anything else you feel like the board needs to know or you would like the board to know at this time?
No, I don't think so.
Okay. What I plan on doing is taking the information we discussed today, compiling that into a report and submitting that to the board. The board is made up of 5 members. It takes a majority vote for them to make a decision in your case. It usually takes about 2 to 4 weeks for them to get that decision out to you. You currently have a guideline of 32 months, which puts you at December 28th, 2024. That guideline is what it is just a guideline, meaning the board can go past that if they choose that it's necessary. They will take into consideration the fact that you have completed sex offender programming prior to this hearing as well when making that decision. You do have an expiration date of April 28th, 2027. That is the length of time the board will have jurisdiction over your case, given there are no other further offenses. Do you have any other questions for me, sir?
No, ma'am.
All right, with that, we'll go ahead and conclude this hearing. Thank you. Good luck to you and have a good day.
All right, thank you. You too.
Those of you already familiar with Utah will know that Utah did grant this cockroach parole, if you can imagine. Now, let me tell you things that are just going to get you riled up. This is absolute madness at its finest. He has a long record. Now, he has 3 convictions, 2000, 2014, 2022, and 4 convictions in 2022. But those are just convictions. He has many other offenses in his record. As he stated himself, at least 10 victims. But don't buy into his manipulation. This guy does not care. He is a roach of the highest degree. He went to trial for this. A jury found him guilty. He didn't take a plea deal. He went to trial. The 10-year-old and 12-year-old girl had to get on a stand and talk about this. When he was found guilty, it took just an hour of deliberation. I'll read through it. The judge sentenced to the max. The judge had his hands tied. The maximum sentence was 0 to 5 years. It's written in Utah's legislation. So if a man goes to a girl in a store and does that, the maximum a judge can do, even if he takes them to trial, is 0 to 5 years. So why wouldn't he go to trial, right? But you would think the parole board would say, you know what? This is literally a classified in the books. He is a poster child of a serial offender. You'd think the parole board would have some respect, at least for the judge and the system, but no. They released him 3 years early. Why? I don't know. Because they're psychopaths? I just don't know. But this isn't the first time that he took a young child to a jury trial. And I'll read through that as well. That little incident he was talking about, how he described it as, oh, I don't know, I was at church with the family friend, and I don't know how he described it. He wrote it off. No, what happened is they took him in as a nice church family would do, and he starts. He actually confesses his love to the 12-year-old. He tells the parents that he loved her. Well, they kicked him out of the house, of course, and then he would stalk her. And he was stalking her enough that they got the police involved, similar to that intro case that I just showed you, right? And he took them to a jury trial. Jury found him guilty. He appealed, and the Supreme Court of that, whatever it was, overturned it. So he got that conviction overturned. So this is a roach that has a serious problem with defending on little ones, has victims spanning over maybe 30 years now, goes to jury trials, puts these children on the stand, and the Utah Board of Paroles releases him early. You can't make it up. Now I'm going to read to you. I had to get that off my chest. I'm going to read to you the information. And thank you, Sir Richard. When he saw this case, he said, Mandy, you have to cover this one more. We have a long list of cases to cover. It's crazy. Just out of Utah, hundreds that I need to get to. This one, it's just insane because they just released a predator who will, in my opinion, strike again. And they did not need to do that. A 54-year-old North Logan man has been sentenced to prison after being convicted of exposing himself inside a local store several years ago. He was given the maximum sentence after a judge learned there were similar instances in the past. So again, this is Utah legislation that is handcuffing the judge. But the parole board, the last line of defense, he was sentenced Monday morning in First District Court. He was previously found guilty on one count of lewdness involving a child, third-degree felony. In August of 2020, Logan City police officers were called to the retail grocery store after two girls claimed that he exposed and pleasured himself in the store aisle. The children aged 10 to 12 had reported the incident to their mother, who notified employees. Later, it was determined that the 10-year-old did not actually witness the crime. In an interview conducted by investigators with the 12-year-old girl, she described how he had approached her in the toys department store, exposed himself while winking at her. Mind you, this is the same man who said he fell in love with the 12-year-old. This is the same man who has 3 prior convictions, including this one. Following the 2-day trial in April 2022, a jury found him guilty. You know, at least give the DA credit for going through with the trial and not letting him get away with the plea deal. But he might as well have done the plea deal because he only got a couple years anyways, huh? During, I bet you they did offer him plea deals, and he knows the system. He's a clever little roach, and he probably has gotten away with it so many times by calling the state's bluff. He probably has gotten away with it many times by calling their bluffs and them just deciding not to go to trial. I know it. If he's so comfortable going to trial, you just have to, it's my opinion that he's probably done this many times before, where then they just drop the charges. Cache County Deputy Attorney Ronnie Keller asked for Joyner to be sent to prison. He said the defendant was a registered sex offender and previously been convicted of exposing himself to other young girls in Salt Lake City. The crimes reportedly occurred at a playground and a library. I mean, you can't make it up, of course, right? He needs to go and take what's sacred to our children. Safe zones. Let's take playgrounds and libraries. Why not? Judge Spencer Walsh said Joyner had an impulse control problem and needed to be honest with himself about his attraction to children. He ordered the defendant to serve the term of 0 to 5 years in prison. That's legislation. The maximum the judge was allowed to sentence. I'm sorry for bringing a broken record, but think about that. Lawmakers in Utah actually have in their code that if a man is convicted, found guilty, goes through the expense of a trial, and the jury finds him guilty, the maximum a judge can sentence him for doing this is 0 to 5 years, not 1 to 5 years, not 2 to 5 years, not what we would think. Maybe it can be, the judge could say, well, there are priors. Maybe it should be 20 years. He's an habitual offender. No, 0 to 5 years. Make it make sense. But we don't. We're just sheeple, right? We don't understand lawmakers. We don't have PhDs. How dare we question those in charge put in charge to protect us? This is insane. Like, I just want to ask a lawmaker, really? Why? Why is this important to you to protect a sicko like this? Joyner still has another similar pen. He had another pending. How does he have a pending case that reportedly occurred in 93? How do you have a pending case from 93? He was ordered to appear August 1st for preliminary hearing. Okay. So now let me share with you what's going to disgust you. Well, I think I already told you how it was overruled, but I'm going to share with you the transcript of it. We'll go through it. So this was the other case that was brought up here. Remember how what did he say? What were the words that he said? Let me go back and listen and tell you. Okay. I just re-listened and wrote it down, and how he described this, what I'm about to read to you, was that he was living with in that home. They found out he was a registered sex offender. They did not like that. So he was trying to keep the relationship open, and he was overly aggressive at trying to keep the friendship, and it led to a struggle. That is how he articulated what led to a jury trial, what led to them placing their daughter on the stand. The victim, a 12-year-old female, lived with her father and stepmother in McCoyne. This cockroach, a 45-year-old man at the time, attended the same church as the victim and her family. The victim's family invited them to live in her home. And you know what? Like, again, he literally picks churches to prey on their victims. He picked them. Okay? We know that by now. On January 25th, 2013, he told the victim's stepmother that he had romantic feelings for the victim. Can you imagine being told that? Joyner said that he believed he and the victim were soulmates. 3 days later, the victim's father and stepmother told him to move out of their home. Why it took 3 days, God knows, but it's whatever. At least they told him to move out. And to discontinue communication with the family, Joyner went into the restroom to whisper something into the victim's ears before he left the residence. How creepy is that? He goes into the she's in the bathroom, and he whispers something into her ear. Also, before he left the home, he gave letters to the victim's father and stepmother and the victim. The letter to the victim's father and stepmother reinforced his feelings toward the victim, apologized for opening up the two about his feelings toward the victim, and asked for forgiveness. This is how he runs it through his mind, right? Joyner's letter to the victim stated that he was returning poems she had written him and that the feelings expressed. Let's see, the poems were included in the Christmas gift the victim's family gave him. You see how twisted his mind is? He's returning poems that she wrote for him. Poems were included in a Christmas gift that the families gave to him, that the family referred to as a girlfriend in a box. According to the victim's stepmother, Joyner asked for a girlfriend for Christmas. So the victim's stepmother, the victim's friend, and the victim herself wrote love notes to Joyner from a hypothetical. And again, this is what they were doing was something like that could have been, it was completely innocent. You get it, but his perverted mind. So they write him something, but he construes it. He actually believes that like that's how his mind works. He believes that these poems are written. Well, he chose to select only the poem from the daughter. Was it's sicko, it's psycho stuff, scary. Victim's poems were consistent with Joyner's feelings about the victim. Shortly thereafter, Joyner was asked to leave the family home. The victim's father and stepmother told the victim that Joyner was a registered sex offender. There was no evidence that Joyner was aware that the victim knew he was a registered sex offender. I hate using last names. It always bothers me. I'll use it William. William continued to communicate with the victim's stepmother via text message. Stepmother told the victim about the text messages. Amongst William's text messages were questions about whether the victim's stepmother was driving the victim to school. In one text message, William stated, I got a feeling yesterday that you were giving the victim a ride to school. So today I parked at the hospital parking lot to see. Don't know for sure, but that's what I think. It's kind of what it looked like to me. What? On February 9, 2013, William parked near the victim's home. William walked toward the home into the yard. The victim saw William through the storm door. Once the victim spotted William, he turned and ran back down the street towards his vehicle. Shortly thereafter, the victim and her family saw William at church. Like, where's small town justice in these situations? You know, this is Utah. I lived in Utah for a little bit. There's a lot of, there's a lot of men carrying their Second Amendment rights, driving pickup trucks. And I just, it's hard to imagine. I mean, there's a lot of big men with big beards. Like, how does this happen? Really? Shortly thereafter, the victim and her family saw the church sat behind. Shortly thereafter, the victim's family at the church. William entered the church and sat behind the victim, who was sitting next to the pew next to her stepmother. The victim moved to sit with a friend, and William moved to sit to her. I'm pissed. Like, I do not understand how there is just not, forget even small town justice, just getting up and just like in front of it making a scene. When the victim's father entered the church, the victim moved to sit next to her father. William again moved and sat directly behind the victim. The victim's stepmother filed a complaint with the police department sometime thereafter. William was arrested in the parking lot of the apartment complex located approximately 3 blocks from the victim's home. After his arrest, he admitted to the police that he had a deep love for the victim, and he thought they were soulmates and that they were meant to be together. William also told police about his contact with the family via text messages. William informed police that he had been to the victim's family house twice since moving out, once to drop off pallets and once when he saw the victim through the storm door. Finally, William admitted that when he noticed the victim was no longer at the school bus stop in the mornings, he sat in his vehicle in a parking lot to determine how the victim was getting to school. The state charged him with 1 count of aggravated stalking, violation of blah, blah, blah. At trial, he goes to trial. The state claimed the act of giving the victim a letter, observing the victim at her home, following the victim to church services, and going to a hospital parking lot to observe the victim constituted stalking via course of conduct. The jury returned a verdict finding him guilty. Now, I'm going to tell you, this was overturned, mind you. Stalking, and recommended a 4-year sentence and a fine to be determined by trial court. The trial court entered the judgment finding him guilty. Aggravated stalking sentenced him to 4 years. And this was, what year was this? This was the appeal was filed 2015. So I think this happened in 2008. Oh no, 2013. 2013. Look how slowly. 2012 to 2013. Now, here's why it was appealed on a freaking technicality. It was appealed and they won on technicality because they left. This is how crazy. This is, again, they left out 2 paragraphs in the instructions. I'll leave a link to this in the description. These are the paragraphs that they left out. They omitted these paragraphs, 3 paragraphs. However, unless you find, and these are the paragraphs that they didn't say. However, unless you find and believe from the evidence beyond a reasonable doubt that all of these propositions, you must find the defendant not guilty of the offense. As used in the instructions, the term harassing means to engage in a course of conduct directed at a specific person that serves no legitimate purpose, to be frightened, intimidated, emotionally distressed. And used in the instructions, the term course of conduct means pattern of conduct imposed 2 or more acts, which may include communication by the means, period, applied. Basically, the judge somehow left out those 3 paragraphs. And because of that, it was overturned. In conclusion, the trial court's judgment of conviction sentence is reversed. It's remanded for a new trial. And I think that they just, it's my understanding that they opted just not to have the new trial. I don't blame them. It's all these years later as well. 5, 6, how many years later? This was 2015. I mean, it would have been 8 years later that the appeal went through the process. That doesn't, but so that's why he gets to say that he doesn't have convictions in other states, I guess. Unbelievable, right? So this guy is just a waste. He's a waste, and he knows that he can keep doing these type of things and get away with it. The sentencing guidelines are not that high. The chances that they'll go to trial are not that high. He knows that things can get overturned. I mean, it's just he's playing the system. He's a cockroach. He's a waste, a drag on society, and a danger to society. And one might only wonder when things are just going to escalate out of control. And but the Board of Parole's release him. Now, how I think this happens, I do believe there's a reason for it, and I believe that it's because these are parole board interviewers. The interviewers are putting things in a computer system, and we cover, just Richard and I alone cover probably per day per day each week, because there's Salt Lake City and Gunnison. I mean, maybe 16 hours of parole hearings a day, 5 days a week. They have hundreds of parole hearings. And then at the end of every week or 2 weeks, the parole board gets in their computer file. I believe, I don't know this for certain, but I believe this is how it must be done. And on that list is just information with boxes and maybe a small paragraph where the parole board interview gives a recommendation. And then they sit at the end of their long day and they go through the computer thing and they click boxes. They don't see it. They're not, how much time do you think they invest in actually looking at the case? It's just wrong. The whole system is wrong. They need to go to like the Louisiana parole system where the whole board is there. They're able to ask questions. They're able to invest the time in it. Invest the time in it. If you don't have enough parole board interviewers, then hire more.
That just kind of a ballpark figure that aren't convicted victims.
That are convicted
That
victims.
aren't
Aren't.
convicted victims.
10 maybe.
Okay.